Good morning, namaskar, sat sri akal and adab. This is my 265th video, and this will be covering in a very detailed manner. I had made some videos earlier on why sale purchase were allowed within these cantonments since 1864 or even prior, but we were unable to lay hands on those sale deeds. But in a case of Purushottam Das Tandon, he did mention a sale deed of 1845. So, what is sale? Purchase of land and how the same was to be registered in records. We would like to state that the British regime started or allowed sale of land, and these deeds were to be registered under the very first regulation 36 of 1793. Vide its section 2 passed on 1st May 1793. This was for Bengal Province or Presidency, and later vide Regulation 28 of 1795, Section 2 for Bundlecund, and Regulation 17 of 1803 for Saharunpore. Later, the same was permitted in 1805, while Regulation 12 for Cuttack and Regulation 8, Section 17, Clause-I for Agra of the Bengal Code. Now imagine, friends, from 1793, there were laws put in place for the Transfer of Properties Act. So, Transfer of Properties Act 1882 is not the first act. The same law or regulations were further substituted by Act 30 of 1838, which read that all sale deeds will be required to be registered and subscribed on oath in front of a judge of the Zilla. This entire regulation of 1838 was repealed by Act 24 of 1856, and the station civil officer was made competent to administer oath of declaration at the office of registrar. So now we are getting that independent officer, because imagine in 1838, 1802, 1856, there were no registrars, there were no DCs, there were no collectors, there were zillas. So what are we pleading? Is that British recognized sale and it being registered with the local judge or officer of the Subha Province, then so-called regulation, even before the Grant Act of 1895 or the Crown Act 1895. So the pleading of the opposite party could be that the Regulation 36 of 1793, Section 2, sale was allowed for freehold properties or agricultural lands. The same is stated that Regulation 8 of 1800, Section 1 and 2 and 3 clearly allowed sales of all lands, whether grants, as much before wide Regulation 38 of 1793, wide Section 5. European officers, by permission, were allowed to purchase grants and lands, and wide Section 6, their European officer name had to be disclosed in the district register by the civil officer. That is why you find those permissions coming in the GLRs, which they say some officer took permission and there is a letter number. So don't get fooled by these executives or their land registers or their grant registers. That the British regime even bought the same regulation 13 of 1806 called the Stamp Act, and each sale purchase will be registered and proper stamp duty had to be paid for the same vide the same act, meaning hereby from 1st May 1793 to 1806, during these 15 years, sale purchase of land was allowed and even registered with the registrar office, who was a judge of the Zilla and later an officer of the same Zilla. Anything left? Now, before the Registration Act 29 of 1856 was repealed by an act of 16 of 1864, we had the making of the first Cantonment Act 1864. In the same, in Regulation 10, it spoke that the cantonment magistrate who was delegated the power of sub-registrar of the area was under the Act 9 of 1865 registration of assurance, was under section 7, was asked to forward all instruments affecting immovable properties registered with the sub-registrar, and the same was to be specifically kept. Likewise, wide section 56 of Act 16 of 1864 or wide section 51 of Act 3 of 1877 or section 7 of 1865. Now, what had to be kept? That is very important. Following books will be kept. Book number 1, Register of Non-Testimoniary Documents Relating to Immovable Properties. Book number 2, Record of Reasons for Refusal to Register. Book number 3, Register of Wills and Authorities to Adopted, and book number 4, Miscellaneous Register. Now, this book number 1, which is registered of deposits of all the wills, is very important. That the British regime, even wide Regulation 15 of 1838, allowed the proprietors of land to make a will of his immovable property, whether it was land or agriculture land or grant, meaning hereby that your and my bungalow or estate, since the inception, was permissible for sale through law and was legally willed to the inheritor by a bloodline or extended family. That this was done by Regulation number 30 of 1839, inheritance of all such lands grants could be inherited much before the Crown Act or the Grant Act 1895. That after the Cantonment Act 1864 came the Cantonment Act 1880 and later 1889. It's section 32. Now I'm going to read the Cantonment Acts. 1, section 54, para 2 and 3, and section 59, 107, and 13 of the Transfer of Properties Act 1882 with respect to the transfer of property by a registered instrument shall on and from the commencement of this act extend to every cantonment in British India. 2. Where a cantonment has not been constituted, a sub-district or district for the purpose of the Indian Registration Act 1877, under Section 9 of that Act, the registrar of the district in which the cantonment is situated shall cause a copy of such entries in Index number 1 and 2 as relate to immovable properties within the limits of the cantonments to be forwarded to the cantonment magistrate annually or at such shorter interval as the local government may prescribe. This pleading made by a resident or us stands proven that sales purchased within cantonment boundary pillars or named to be the military bazaar was allowed whether after the Cantonment Act 1910, 1924 or 2006. All stated that sale of grant was allowed. Even the Cantonment Land Administration Rules 1925, 1937 too gave permission of sale and the maintenance of record of right, which states that we are old grants, which was approved by the British on in 1st May 1793 as revenue free grants and stood acceptable and approved by the Board of Revenue Officers till 1859. Now, this video is purely on law and facts. And friends, I may share, I have all these regulations in my custody. I have dug into all these documents. None needs to get worried. We can very easily, with my help, can lead evidence, can plead, because I've been continuously saying we were revenue free grants, transferable grants, and that is why our GLR till date, having 13 columns, does not specify the Board of Revenue's order of what lagan are we paying on these grants. Thank you. Good day.